The United States House of Representatives has just passed three groundbreaking immigration reform bills in February 2026 that will fundamentally reshape how immigration works in America. After months of intense negotiation and political maneuvering, these bills moved through the House this week with bipartisan support, shocking political observers who expected continued gridlock. The changes these bills bring will affect millions of immigrants, visa holders, green card applicants, and undocumented individuals. Currently living in the United States, Texas, as the state with the longest border and second largest immigrant population in the nation, will experience these impacts more dramatically than almost anywhere else. Whether you are waiting for a visa approval, applying for a green card, seeking asylum, working on a temporary visa, or living undocumented and worried about your future. What just happened in Washington will directly determine your path forward. The next 6 months will be critical for every immigrant in America. Welcome back to U.S. Visa Info, your most trusted source for breaking immigration news, in-depth policy analysis, and practical guidance for navigating the complex United States immigration system. My mission is to deliver facts without political bias, to explain complicated legislation in plain language, and to give you actionable information that helps you protect your status and achieve your immigration goals. If you are new here, please subscribe to U.S. Visa Info and activate that notification bell because immigration policy is shifting rapidly in 2026, and being informed in real time could literally save your case or change your life. Today, we are analyzing the three immigration bills that just passed the House of Representatives, breaking down exactly what each bill contains, who will be affected, what happens next as these move to the Senate, and most critically, what actions you should take right now to prepare for these changes. This is the most significant immigration legislation to pass the House since the EUR's comprehensive reform attempts of 2013, and every detail matters. The first bill that cleared the House is called the Secure Border and Interior Enforcement Act of 2026. This legislation focuses heavily on border security, infrastructure, enforcement expansion, and consequences for illegal entry. The bill authorizes $32 billion over the next 4 years, specifically for physical barriers, technology systems, and personnel along the southern border. The funding breakdown includes $12 billion for wall construction and barrier reinforcement in Texas, Arizona, New Mexico, and California, $8 billion for surveillance technology, including towers, drones, and sensor systems, and $12 billion for hiring and training new enforcement personnel. The personnel expansion is massive. The bill mandates hiring 15,000 new Border Patrol agents over the next 3 years and 8,000 new immigration and customs enforcement officers. Training mines will be established in Texas, specifically in the El Paso and Rio Grande Valley regions. For communities throughout Texas, this means a substantial federal law enforcement presence that will be visible not just at the border, but throughout the interior of the state as ICE operations expand. One of the most significant and controversial changes in this bill is the elimination of humanitarian parole for most asylum seekers at the southern border. Currently, many migrants who present themselves at ports of entry and claim asylum are paroled into the United States while their cases are processed. This bill ends that practice. Instead, asylum seekers will be held in newly constructed processing centers located on the Mexican side of the border or in third countries that have signed agreements with the United States. Only after initial asylum interviews demonstrate credible fear will applicants be allowed entry into the United States. The bill allocates $5 billion for constructing and operating these offshore processing centers. The stated goal is to discourage fraudulent asylum claims and ensure that only legitimate asylum seekers enter while their cases are adjudicated. Critics argue this violates international refugee law and puts vulnerable people in danger, while supporters claim it restores order to an overwhelmed asylum system for people already in removal proceedings. The bill creates expedited docket systems. Immigration courts will be required to complete cases within 6 months for detained individuals and 12 months for non-detained individuals. Additional immigration judges will be hired to meet these deadlines. While faster processing Sounds positive? Immigration advocates warned that the compressed timelines make it nearly impossible for applicants to gather evidence, find attorneys, and present strong cases. The bill also dramatically expands the crimes that make immigrants deportable. Previously, only aggravated felonies and crimes of moral turpitude triggered mandatory removal. The new bill adds a category called crimes affecting public safety, which includes DUI convictions, domestic violence misdemeanors, certain drug possession offenses, and repeat traffic violations. Even lawful permanent residents can be placed in removal proceedings for these offenses. Juan from Houston has been a green card holder for 12 years. 3 years ago, he was convicted of DUI. He paid his fine, completed probation, and thought the matter was closed. Under this new bill, his DUI conviction would make him deportable. ICE could place him in removal proceedings, and he would face deportation to a country he left as a teenager. His only defense would be to apply for cancellation of removal, which requires proving that his removal would cause exceptional and extremely unusual hardship to his U.S. citizen children. The standard is very high, and many applicants fail. The second bill passed by the House is the Legal Immigration Reform and Backlog Reduction Act of 2026. This legislation takes a dramatically different approach from the enforcement-focused first bill. It aims to modernize the legal immigration system, reduce backlogs, and create new pathways for skilled workers and family members. The centerpiece of this bill is the elimination of per-country caps for employment-based green cards. Currently, no more than 7% of employment-based green cards can go to nationals of any single country in a given year. This creates devastating backlogs for applicants from India and China, where highly skilled workers wait decades for green cards. The new bill eliminates these caps entirely, allowing green cards to be issued based on priority date regardless of country of birth. This change will dramatically reduce wait times for Indian and Chinese nationals in the EB2 and EB3 categories. The bill also increases the overall annual cap on employment-based green cards from $140,000 to $250,000. Additional increases are triggered automatically if demand exceeds supply in any given year. This expansion addresses the reality that the American economy needs skilled workers, particularly in technology, healthcare, and engineering fields. For family-based immigration, the bill makes significant changes. The annual cap for family preference categories increases from $226,000 to $350,000. The bill also creates a new fast-track category for parents of adult U.S. citizens. Currently, parents can immigrate without numerical limits, but processing takes years. The new fast-track system promises processing within 12 months for parents who meet financial and health requirements. However, the bill eliminates one category that will disappoint many applicants. The sibling category, which allows U.S. citizens to sponsor their brothers and sisters, is removed entirely. Current applicants in this category will be grandfathered and can continue, but no new sibling petitions will be accepted after the bill becomes law. The visas freed up by eliminating the sibling category are reallocated to other family categories and employment-based categories. The bill also addresses the diversity visa lottery, but unlike earlier proposals to eliminate it entirely, this bill maintains the program while reducing it from 50,000 visas annually to 30,000. The freed-up visas are redistributed to clear family-based backlogs. One major innovation in this bill is the creation of a new visa category called the Startup Entrepreneur Visa. Foreign nationals who can demonstrate they have founded or will found a business that creates jobs and generates revenue can obtain a special visa that provides work authorization and a direct path to a green card within 3 years if they meet job creation and revenue targets. This visa is designed to attract immigrant entrepreneurs and compete with other countries that have similar programs. Texas, with its booming technology sector, energy industry, and healthcare system, stands to benefit enormously from the employment-based reforms. Companies in Austin, Dallas, Houston, and San Antonio that struggle to hire and retain foreign talent will have more options. Workers trapped in decades-long backlogs will finally see movement. However, the elimination of the sibling category will hurt Filipino, Mexican, and other immigrant communities that relied heavily on that pathway. The bill also modernizes visa processing by requiring USCIS to implement full electronic filing, online case tracking, and digital interviews for most applications within 2 years. Premium processing will be expanded to nearly all visa categories, allowing applicants to pay for 15-day processing. While this creates a two-tiered system that benefits wealthier applicants, it also generates revenue to fund faster processing for everyone. The third and most politically contentious bill is the Earned Pathway to Legal Status Act of 2026. This bill creates a conditional pathway to legal status for certain undocumented immigrants currently living in the United States. It does not provide immediate citizenship or amnesty, but rather establishes a lengthy process with strict requirements. To be eligible for this program, you must meet several conditions. First, you must have continuously resided in the United States since January 1, 2020. This is the cutoff date. If you entered after this date, you do not qualify. Second, you must have no felony convictions and no more than 2 misdemeanor convictions. Third, you must demonstrate continuous employment, enrollment in education, or status as a primary caregiver for dependent. Fourth, you must pass background checks and biometric screening. Fifth, you must demonstrate basic English language ability and knowledge of U.S. civics. Individuals who meet these requirements can apply for what the bill calls conditional residence status. This is not a green card or citizenship, but a temporary legal status valid for 8 years. During these 8 years, you must maintain continuous employment or education, pay all taxes, not commit any crimes, and check in annually with immigration authorities. After completing 8 years in conditional resident status, if you have met all requirements without interruption, you can apply to adjust status to lawful permanent resident, meaning a green card. After obtaining your green card, you must wait an additional 5 years before applying for citizenship through the standard naturalization process. This means the total timeline from undocumented status to citizenship under this program is at least 13 years. The bill includes special provisions for dreamers, individuals who were brought to the United States as children. If you entered before your 16th birthday, have lived in the United States for at least 10 years, and have graduated from a U.S. high school or obtained a GED, you qualify for expedited processing. Dreamers can obtain conditional resident status immediately and adjust to permanent residency after just 5 years instead of 8, cutting the pathway to citizenship down to 10 years total. The application process requires extensive documentation proving continuous residence since January 2020. Acceptable documents include rental agreements, mortgage statements, utility bills in your name, bank statements, employment records with pay-ubs or tax documents, school enrollment records, medical records with dates of service, and sworn affidavit from U.S. citizen or permanent resident witnesses who can verify your presence. Many undocumented immigrants live in circumstances where obtaining formal documentation is difficult, such as paying rent in cash, working off the books, or sharing housing without their names on leases. The burden of proof required by this bill will be extremely challenging for many applicants. The fee structure is substantial. The initial application for conditional resident status costs $2,000 per adult and $1,000 per child. After 8 years, the application to adjust to permanent residency costs another $12,500 per person. Combined with eventual naturalization fees of $760, a family of 4 could pay over $15,000 in government fees alone over the 13-year process. This does not include attorney fees, document translation, or other associated costs. During the entire period of conditional resident status, applicants are explicitly prohibited from receiving federal public benefits. This includes Medicaid except for emergency services, SNAP food assistance, federal housing programs, and subsidies under the Affordable Care Act. You can work legally and pay taxes, but you cannot access the social safety net even in times of hardship. Only after adjusting to lawful permanent residence do you become eligible for these programs, subject to the usual waiting periods. Texas has an estimated 1.7 million undocumented immigrants. If this bill becomes law, potentially 800,000 to 1 million could be eligible based on the January 2020 residency requirement. Major metropolitan areas like Houston, Dallas, Fort Worth, Austin, and San Antonio have large undocumented populations who have established deep roots, raised families, and built lives over many years. This bill offers a chance at legal status, but the path is long, expensive, and filled with requirements that will exclude many. Rosa from San Antonio entered the United States illegally in 2018 with her 2 children. She has been working as a housekeeper, pays rent, and her children attend public school. She would qualify for this program because she has been here continuously since before January 2020. She has no criminal record and steady employment. However, she faces significant challenges. She must prove she has been in Texas since 2020, which means gathering years of documents. She has moved apartments twice, and her earlier landlords may not remember her or be willing to provide letters. She has worked for different families, some of whom paid her in cash without documentation. Building a strong application will require months of effort and possibly hiring an immigration attorney, which she can barely afford. It is absolutely essential to understand that these 3 bills have only passed the House of Representatives. They now move to the Senate, where the political landscape is very different. The Senate is narrowly divided, and immigration remains one of the most divisive issues in American politics. Several scenarios are possible. The bills could pass the Senate largely unchanged if enough senators from both parties support them. The bills could be significantly amended through negotiation with provisions added, removed, or modified to gain more votes. The bills could be combined with other legislation in a larger package. Or the bills could fail entirely if they cannot gain the 60 votes needed to overcome a filibuster. Even if the bills pass the Senate, they must be signed by the president to become law. The president has publicly expressed support for comprehensive immigration reform and has indicated these bills align with administration priorities. However, specific provisions, particularly some of the enforcement measures, may face opposition from within the administration. Negotiations between Congress and the White House could result in changes before final enactment. Assuming the bills do become law, implementation will not happen overnight. Federal agencies must write detailed regulations explaining how the laws will be applied. USCIS must create application forms, build computer systems, train staff, and establish procedures. The Conditional Resident Status Program would likely take 8 to 12 months after enactment before applications can even be accepted. Border enforcement provisions would be phased in as funding is appropriated, personnel are hired, and facilities are constructed. Changes to visa categories and processing would require systems updates and staff training. What should you do right now to prepare? First, if you are undocumented and potentially eligible for the Earned Pathway program, start gathering documentation immediately. Do not wait for the bill to become law. Collect every piece of evidence showing your presence in the United States since January 2020. Request letters from landlords, employers, schools, doctors, churches, and anyone else who can verify you are here. Make copies of utility bills, rent receipts, money transfer records, anything with your name and a date. Organize these documents chronologically in a secure place. If the bill becomes law and the application window opens, you want to be among the first to apply. Second, if you have been paying taxes using an individual taxpayer identification number or ITIN, make absolutely certain you file your 2024 and 2025 returns on time. Tax returns are one of the strongest pieces of evidence for proving presence and demonstrating good moral character. If you have not been filing taxes, start now. Even if you earned income off the books, consult with an immigration knowledgeable tax professional about filing returns that document your work history without exposing you to other risks. Third, avoid any criminal activity, no matter how minor. Even a misdemeanor conviction could jeopardize your eligibility. If you have old criminal cases that were dismissed or resolved favorably, obtain certified court records showing the disposition. You will need these documents for your application. Fourth, if you are in the United States on a temporary visa, be meticulous about maintaining your status. Do not overstay your authorized period. Do not work without authorization and keep your address updated with USCIS. The bills expand penalties for status violations, and even minor violations could affect future applications. Fifth, If you are waiting in the employment-based green card backlog, particularly from India or China, the Legal Immigration Reform Act could dramatically reduce your wait time if it becomes law. However, do not make irreversible life decisions based on pending legislation. Monitor the situation closely, but maintain your current status and continue with your existing applications. Sixth, if you are a U.S. citizen planning to sponsor a sibling, understand that this category may be eliminated. If you have not yet filed an I-130 petition for your brother or sister, do so immediately. The bill includes a grandfather clause protecting petitions filed before enactment. So filing now preserves your sibling's place in line even if the law changes. Seventh, be extremely vigilant about immigration fraud. Whenever major immigration legislation is pending, scammers multiply. They promise help with applications that do not yet exist, charge fees for services they cannot provide, and take money from vulnerable people desperate for legal status. Only work with licensed attorneys or DOJ-accredited representatives. Never pay cash without receipts. Never sign blank forms, and never let anyone keep your original documents. Eighth, if you are an employer who sponsors foreign workers, start planning now for potential changes. If the employment-based reforms pass, you will have more options for hiring and retaining talent. Work with your immigration attorney to identify current employees stuck in backlogs who could benefit from the changes and prepare to act quickly when the new rules take effect. The passage of these three immigration bills through the House represents a historic moment. For the first time in over a decade, comprehensive immigration legislation addressing enforcement, legal immigration, and undocumented populations has moved forward with bipartisan support. Whether these bills ultimately become law remains uncertain, but the fact that they passed the House demonstrates that political will for immigration reform exists even in a divided government. For immigrants throughout Texas and across the United States, these bills represent hope, anxiety, opportunity, and risk at once. The enforcement provisions create new dangers for undocumented immigrants and expand grounds for deportation. The legal immigration reforms offer relief to hundreds of thousands stuck in backlogs and create new opportunities for skilled workers. The earned legalization pathway provides a chance for millions to emerge from the shadows. Though the requirements are steep and the road is long, here at US Visa Info, we will monitor this legislation every step of the way. We will track the Senate debate, analyze any amendments, report on final passage or failure, and most importantly, provide you with detailed guidance on how to navigate these changes if they become law. Immigration law is complicated. The political process is unpredictable and reliable information is hard to find. That is why this channel exists, to give you the facts, the analysis, and the practical advice you need. If this video helped you understand the three immigration bills that just passed the House and what they could mean for your future, please hit that thumbs up button and share this video with family, friends, and anyone in your community who needs this information. Subscribe to US Visa Info if you have not done so already, and smash that notification bell so you receive instant alerts as this situation develops in the Senate and beyond. Drop a comment below telling us how these bills would affect you personally. Are you eligible for the earned pathway? Are you waiting in an employment backlog? Are you worried about enforcement? What questions do you have? Your engagement helps us create content that addresses your real concerns. Your future matters, your family matters, your American dream matters. Stay informed, stay prepared, and never stop fighting for your place in this country. This is US Visa Info, and we are here with you every step of the way.